Good morning. This is the appointed time and we have a quorum. Let me first invite the administration to come in. Mr. Tony Chair, page 13, is that right? Let me remind members that in accordance with Rule 83A of the Rules of Procedure, if you have any direct or indirect pecuniary interest in relation to item being discussed today, please disclose the nature of the interest before you speak. Let me first of all welcome the administration to our meeting. Members, as you may have known, we've received from Mr. Frankie Yik a proposed amendment in relation to this bill dated the 18th of October. The paper was already served on members via CB bracket 4905/2023 bracket 01 on the 19th of October 2023. The proposed amendment has been referred to the administration for a written response. After we complete scrutiny of the two bills, I will proceed to handling Mr. Yik's amendment. Members, if you wish to move amendment to any of the two bills, please forward the draft in both Chinese and English to the Secretariat for consideration by our committee. Members, please note that the issues arising from the last meeting are set out in the agenda dated the 16th of October 2023. The Secretariat just received a reply from the administration. I will invite the administration to walk us through this response. We provided a written response to the items raised. Let me help walk members through the salient points. That is in relation to the interpretation of the term taxi under Cap 374, whether general taxis should be covered. Apart from referring to the relevant provision on the definition, the interpretation clause relates to taxis in general. There is no distinction between general taxi and fleet taxi. So we believe that as far as the interpretation in Cap 374 is concerned, there is no need to have separate interpretations. As for the next provision, it applies only to a fleet taxi. So we want to retain the word for identifying fleet taxi. Now, for general and fleet taxis, the interpretation taxi is the reference for the term taxi is contained in the interpretation clause of Road Traffic Ordinance. So this will be a circular argument if we provide a separate interpretation. Now, under the fleet taxi system, the licensee, upon securing approval from the Transport Department, will have autonomy in designing delivery and the signs. So this will help the public differentiate between a fleet taxi and a general taxi. In the front and back of the taxi, the identifying plate should be displayed, which shows the areas that the taxis could ply, such as the red for urban taxis and green for New Territories taxi, as well as blue for Lantau. We will make use of different publicity channels to help members of the public understand and identify the different taxis. As to whether as to how we should distinguish between a taxi that has been pre-booked, usually a card not in service will be placed in front of the taxi meter for the public to identify that this taxi is not in service. So we also need to devise something similar for a fleet taxi for the purpose of distinction. Now, about the reference to painted and painting, in accordance to Regulation 47 of 374A, each taxi should be painted with a coating as gazetted by the Commissioner for Transport so as to distinguish the area of service of the taxi. We believe it is quite difficult to change the coat of paint. We believe that as far as enforcement is concerned, it will be effective in guarding against unlawful alteration of the coat of paint. Thank you. Mr. Chen Xiuhong. Thank you. About general and fleet taxi, I just listened to the administration's explanation. There is no need for any distinction in the interpretation clause. The word taxi should apply to both, but for the fleet taxi, we will be encountering some new situations, such as a designated waiting area for fleet taxis. Now, if the fleet taxi is available for hire in the street, it can be treated as just a general taxi. I think we need to make it clear in this bill why we should no longer distinguish between general taxis and fleet taxis, because that's the administration's response. We need to make sure that the law is clear and accessible. There is a need to make this distinction. Well, if the taxi is allowed to take passengers in the street without pre-booking, then it is akin to a general taxi. There should be a separate provision for general taxis and the fleet taxis. At this point, fleet taxis enjoy this flexibility. They can also function as general taxis. That means the fleet taxis will carry extra functions as compared to those of general taxis. Because these are the problems I identify in the bill. Will there be implications if we mix the two? So that's the point I wish to make. Perhaps the administration can give it a thought. If you want to incorporate the views, you can do so by proposing amendments later. Well, unless you accept the view now, there is no need to add to your answer. You want to supplement still? All right. But if you just repeat your answer, please don't waste our time. Right. In short, as far as the law is concerned, there is a separate definition for fleet taxi and a separate taxi. To address Mr. Chan's concern, for the term taxi, we have a separate definition, general taxi and fleet taxi. These two terms are defined clearly in the law. I want to tell members that we have had a number of meetings. We're at the clause-by-clause scrutiny stage. Of course, questions are welcome, but I want to make sure that these are points of clarification. If it's just a comment, then would the administration please limit yourselves to just clarifying the situation? Please refrain from commenting on the matter. Again, it's for you to decide whether to propose any amendment. I just want to supplement, if I may, Chairman. I fully agree that we are at the stage of clause-by-clause scrutiny. We should go through each and every clause. However, the administration just responded to my question by referring to fleet taxi, and I think it relates to the legislative intent. I believe I should pursue this question because, after all, this is something new. Because what the administration's reply entail will constitute the legislative intent of the bill. Right, but please be succinct because every member would like to add their views. If I allow all members to do so, we'll be spending a lot of time on this. Mr. Tony Chair, 3 minutes. Yes, Chairman, I want to clarify the point about a pre-booked taxi. For a taxi in service not carrying passengers, that means the taxi is available for hire. But about this not in service sign, is this a legal requirement? Where do I find this provision? And for the identifying mark or plate, are there clear stipulations? I'll defer to the Commissioner for Transport to take this question, or the Transport Department representative. It's not required by law at this moment. Well, then, Chairman, please give it a thought. We didn't have the pre-booking mechanism in the current legislation. We're going to have fleet taxis that will allow pre-booked service. I think that at least the tourists will not be able to distinguish if you put up an illuminated sign, and they may have the perception that the taxi driver is picking passengers. A response from the administration, please. So you go back and give it a thought, right? Yes. Well, I think the current arrangements is clear to locals. What about tourists? I believe they are clear about that as well. Mr. Frankie Yik, you also want to chip in? Well, I think I made this point before. We can make reference to Singapore if there is a pre-booked trip and the taxi driver is on his way. A plate will be displayed on the windscreen, and it will be very clear for everyone to see that this taxi is not for hire. At this moment, and I concur with the other member, that we just put a card in front of the taxi meter saying not in service, and this can mean different things to a tourist. I just believe we should learn from Singapore. So one is not in service. The other is on his way of picking up a passenger, right? I mean, it's not in service as such, but there is a clear sign that the taxi driver is on his way to pick up a passenger. Now, for refuse to hire, very often the explanation is that the driver is about to knock off and they're in the wrong direction. Now, in Singapore, however, it clearly stipulates where the taxi driver is going to pick up a passenger. Sorry, I am entrapped as well. How do you distinguish the two? Because for passengers, they only see this illuminated sign. If you're on your way to pick up a passenger, you should not put up this sign. Well, I think a lot of questions have been put, including those in previous meetings, and we are just coming from the user's perspective. We are trying to bring more benefits and improve the bill. You need to address the needs of the public because, of course, if you can address these concerns, there won't be so many questions. We all strive for improvement, right? So instead of just a perfunctory response, you should go back and think about our questions. I think that this is what all government departments should do, not only your bureau. It's futile just to make minor improvements. Ms. Doreen Kong, 3 minutes. About Annex A, I made a point last time. And Chair, I'm afraid I can't agree with what is set out here. I'd like to pick up on what others said. Now, the principal ordinance is Cap 374. For the interpretation clause, it is here for people to understand what exactly this bill is about. Now, last time I said that instead of making major changes, we should have a definition for general taxi and a definition for fleet taxi. Under Cap 374, you can't just arbitrarily say that the taxi includes general taxis and fleet taxis, because the interpretation clause sets out in detail the definitions of different classes of vehicles, like motor vehicle, motorcycles, and so forth. You should not take a broad stroke and just call everything a taxi. As a member of the public, I want to make sure that just by reading the interpretation, I will have a clear idea what they are, so that I don't need to refer to the subsidiary legislation to check what a general taxi and a fleet taxi mean. I don't agree with the administration.
Well, your observation is noted. All right. Frankie has spoken. No other member would speak at this juncture. Let's return to clause 11. Let's continue with our cross-by-cross examination. If you use the markup copy, it's page 0013. Over to the administration for the bill. It's markup copy, page 13, clause 11. It's amendment regulation 53 amended, saying that unless a taxi belongs to a taxi fleet, then the marking of a taxi fleet cannot be affixed to a general taxi. And then 12, markup copy, page 14. Ms. Doreen Kong, sorry, I have a question. 1A. I'm curious if a general taxi is in service, they cannot have painting or marking so closely resemble that those of other taxis. How would I know what are the markings or painting of another fleet? If a fleet has a frog as a marking, does it mean that my vehicle cannot have the same marking? That is a frog? In other words, in the future, do I know what other marks have been used by other vehicle? Because it says no vehicle shall be marked in such a way. We are proposing that the taxi fleet can have their own marking. They should come up with some unique marking so that people can recognize them. The commissioner would then give approval. If it's a figure or a marking in the form of a character or figure, we will be very careful. We will make sure that the public will know which markings or figures have been used. How about the size? Where would it be? Where can one find the marking? At the front, at the rear, whatever? Because many vehicles have different markings. For example, they may have some indication of membership of associations. You say you would be the gatekeeper to prohibit unauthorized marking. But how can people tell? So what about contravention by any other vehicles in respect of unauthorized marking? Well, the marking will be outside the body of on the body of the vehicle. We give them flexibility to come up with the right design. Well, we are not prepared to dictate the size of the marking. In the future, we will give some publicity to the marking of certain fleets. What about other vehicles? What will be the penalty for for contravention. We need to check because it's not in this bill. All right, please remind us later. Mr. Chan Siu-hong, let me see if my understanding is correct in regard to the observations made by the two other members. When a vehicle license is issued, the Transport Department or Commissioner will have to approve the color of the vehicle body or the marking on the vehicle. So you would check and ensure that you will not cause any misunderstanding. Is my understanding correct? Secondly, Regulation 53 refers to general taxis and taxi fleets, and the markings on those taxis would have to be subject to approval or color schemed by the Commissioner. What if they choose to have the same color as general taxis? If the answer is yes, they can do this, then people on the street will not be able to tell which is which, whether it's a general taxi or it's a taxi belonging to a street. Would you specify in the law what is prohibited? The understanding of the first point is correct, Mr. Chan. What's the second point? Well, you allowed the taxi to have special marking approved by the Commissioner. Can the operator retain or use the same color as the colors used by general taxis, so they look like a general taxi? Would that cause confusion? If it's not allowed, perhaps you should specify in the law that they cannot use the same color schemes of general taxis. Didn't you mention this last time? No, because we hadn't proceeded to this detail. Well, we want to make sure that a taxi fleet is identified as a taxi fleet. It can be used either by color or marking. So when an application is submitted for the formation of a taxi fleet, the applicant will have to inform the Commissioner of the design of the market. If they use the red color, and then there will be a special marking on the vehicle, the Commissioner would ensure that this is easy to identify. I don't know whether this scheme is viable. So perhaps when someone applies to form a taxi fleet, they would retain the original color in case the scheme doesn't work out. In a year's time, they may want to revert back to previous operations. If this is not allowed, you should specify in the law. Well, there's a provision in the law saying that the taxi fleet should be marked and painted in the color specified by the Commissioner. That would be in accordance with the design approved by the Transport Department when an application is submitted to the Commissioner. You're talking about public light bus, private light bus, and now you want to add the taxi fleet and general taxi. In the past, the design is the general design approved by the Transport Department. But now different taxi fleets may have different markings. And you say no other vehicles shall be marked with the same markings. It will be confusing to the public. Because to me, as a member of the general public, how would I know the markings used by these taxi fleets. Would you standardize the design for taxi fleets? For example, they will be marked taxi fleet in words. Otherwise, it may be very confusing in the future. There's no need to be worried about the confusion that may cause. We'll have a dedicated web page on taxi fleets, and the logos and a design of the markings will be displayed. When different taxi fleets have different brandings supplemented by their color scheme and painting and markings, we don't want other vehicles to copy the design. It's just like the protection, the copyright protection we have enforced. We don't want other vehicles to sort of pose as a taxi in a taxi fleet in particular. Miss Doreen Kwong. No, my car is in red. I have no intention to pose as a taxi, although my car has been frequently misidentified as a taxi. But there's no definition of marking here. I know you'll be doing the vetting, but it's not defined. The word marking is not defined. When a taxi fleet decides on a design, and then there will be a prohibition on other vehicles using the same marking. Why is it that the right prevail over other vehicle owners? For example, if I want to use "I love you" as the marking on my taxi fleet, why is it that no other vehicle would be allowed to use the same marking, that is "I love you", on my car? Why is it the case that the rights prevails over mine? Well, the marking will not be generic in nature. Whether it's a color scheme or it's a marking, it has to be done for the purpose of a certain brand. If they use general words or general marking, it will not be unique in our view. That's why they will have to submit their design to the Commissioner for Transport in the application. They cannot use just English letter, for example, which is indistinguishable from any other people's marking or letter used. So they have to submit a design that would reflect their branding. In that case, please come up with a definition of marking in bracket 1A, because you are talking about unique design, not a generic design. So please consider doing this. Please consider providing a definition of marking. We are talking about the external appearance of a vehicle or of a taxi. For taxi fleet, we hope that they will be booked via the internet or via certain app. So would you require that the taxi fleet will be equipped with electronic payments, such as using a QR code or other payment app? A person will use cash in using taxi service. So would you require that the taxi fleet will be operated on the basis of a mobile app? And there should also be certain requirements on payment systems used for their service.
Yes, I would agree, because we will require the fleet taxis to make use of mobile apps and electronic payments as some of the licensing conditions. Now, DS, I want you to answer my question. Now, fleet taxis would accept bookings, but if there are no bookings, they will be allowed to take passengers from the street. Now, my question is about marking. Are you referring to the livery, the graphic design on the body of the taxi, or are you referring to a markings in the form of a placard or a sticker in the compartment to identify this as a fleet taxi? Say, if I have this fleet taxi A and then fleet B, fleet C for the other vehicles, because then you can have limitless combinations of designs for the fleet taxis. As long as you put up the markings on both the front and back of the taxis using colors to indicate whether it's an urban, new territories, or Lantau taxis. So for the word marking here, are you referring to the livery or a clear identification inside compartment to indicate which fleet this taxi belongs? This is about the livery, that is the design on the body of the taxi. Next, Mr. Dennis Lau. Chairman, I just searched online and I find these compact vehicles being decorated as a bus and then another red private car looking like a taxi. Now, in the future, I wonder whether some private cars would just adopt the same design of a fleet taxi and engage in illegal carriage of passenger, because this is a rather common scene nowadays. Is there any enforcement? How will you tackle it in the future? Will you take enforcement action now? How do you prevent this from happening in the future? Who will take this question, please, DS? This is exactly why we have included Section 53 here. We don't want any vehicle to resemble, on the face of it, a fleet taxi or a public light bus, etc. So this section comes with a penalty clause. We will, of course, maintain liaison with the police, and if necessary, law enforcement action will be taken. Yes, PS, please continue. We move on to page 14, clause 12, amending section 54 of Cap 374A. Under section 54, no taxi, etc., should bear any marking, color marking, sign, etc., other than those permitted under condition of the license or that the commissioner may in writing permit. Now we are adding the reference to a fleet taxi license. That means the taxi fleet license condition may permit so. Next, page 15 of the marked up, section 92 of 374A. This is a minor amendment. We've considered that the illuminated sign may not be fitted on the top of the roof of a taxi, so we are making this amendment. Mr. Rin Kong. Sorry, Chairman, perhaps I'm still puzzled by section 45. Now, if you amend 92C, I understand what you mean. For general taxis, the illuminated sign should be fitted on the top of the roof, whereas for a fleet taxi, there is no such requirement. But if it's not placed on the top of the roof, where should it be placed to indicate that it is a fleet taxi? We've seen examples in other jurisdictions. Both in front and at the back, illuminated signs would be installed to identify the fleet taxi. We don't want to put in too many restrictions on the design. Mr. Frankie Yik, is your question relevant? Is it related to what Ms. Doreen Kong said? It's just a suggestion. We have this taxi illuminated sign for taxis in Hong Kong. What is important is for a fleet taxi, the sign should be placed in front, not the back. By the time you check the sign at the back, the taxi would have gone. So in the future, you should make sure that this sign is clearly visible. Only that it should be clearly visible from the front, not the back. Mr. Tony Chair. Page 15, section 92(1)(a). Just to satisfy my curiosity, why is the current regulation a red light to the front? Why is it showing a red light to the front? Well, I don't think this falls within my remit, but I think that this relates to road safety. This applies to all motor vehicles. Or just for my curiosity, I want to know why we must not have a red light shown to the front. Is it because of the limited choice of color of the light? Mr. Dennis Lang? My question is that in the future, the fleet taxi will not be required to put a sign on the top of the roof. That means for existing taxis turning into a fleet taxi, the sign can be taken off, because for street hailing, a member of the public will need to know if this is a taxi, be it general or fleet. There must be a sign for a passenger to identify, either at the front, back, left, or right. We shouldn't make it hard for a passenger to find out if it's a taxi in service. Apart from the illuminated sign, I also need to check when I hail a cab whether the card is put in front of the meter. That means the passenger will need to check a number of things to find out if the taxi is available. Is it counterintuitive? Well, I don't think you will require signs to be fitted at 10 different places. It will be difficult for passengers. In any case, the word taxi will have to be displayed on both sides of the body of the taxi, and so it will be easy for the passenger to read. If there are no questions, please continue. Clause 14, page 16 to 18 of the marked up copy. This relates to Road Traffic Public Service Vehicles Regulations, Cap 374D. The first amendment relates to the interpretation clause. We will delete the definition for licensee. After introducing the fleet taxi system, we will provide a definition for fleet licensee. So we will have separate interpretations here: passenger service licensee or fleet licensee. Right, Chair, Ms. Doreen Kong. Yes, I have a question about the agreed fare arrangements. Please allow her to finish. We've also included a number of new definitions for fleet taxi, including fleet taxi, fleet licensee, as well as the relevant definitions for terms. As for prearranged journey, on page 18 of the English version, in relation to a fleet taxi means a journey in a taxi that is arranged in advance by booking through electronic means or telephone. So your question, Ms. Kong? Thank you, Chairman. My question is on prearranged journey. In relation to a fleet taxi means a journey in a taxi that is arranged in advance by booking through electronic means or telephone. Why are we limiting the method to just electronic means or telephone? Say after I ride in this taxi, I am satisfied with the driver's performance. Why can't I just there and then book another trip with the driver for tomorrow, face to face? Why must it be electronic means or telephone? Because the fleet licensee will be responsible for prearranging the journeys, and we will come to certain provisions about the requirements, such as a slip documenting the prearranged journey and the fares. And that is why booking should be made through electronic means or telephone. It will not be appropriate for the driver to prearrange a trip. All right, so let's imagine the driver accepts my suggestion of another trip tomorrow, and it's not easy for the driver to call me back. Will there be any penalty if I arrange the trip in this way? I just want to know whether it makes sense. Now, if the booking is not made through the means stated here, he cannot charge the fares according to the provision. Instead, he should charge by meter. So say if I ride in this taxi and then without taking the means has set out here, I just make another arrangement with the driver. I don't need to pay the fares. No, that means you pay the fare by meter, by the meter. But I don't understand, because you talked about fares for a prearranged journey. For prearranged journey, we will have provisions explaining the fare arrangements. It doesn't mean you need to pay in advance. Mr. Tong Chair. Now this is a relevant question, because for prearranged journey, you also have agreed fare arrangements. What if the itinerary is changed? Should another booking be made? Should we keep the original agreed fare? That is as agreed in the prearranged journey. In short, can any change be made after the booking? Yes? If the licensee has agreed with the passenger on the fare arrangements, then the fares should be charged as agreed. Right, what if I want to change the destination? That means the pre-booked trip will be cancelled altogether. I'll need to book again. This undermines the fleet taxi service, and it leaves no flexibility. I just want to know whether this is allowed in the law. For the agreed fare, it is put in place to protect both sides. If you agree that the fare should be so much for one destination to another, the fare should not be changed. Then if you want to change to another destination or add a stop, then as long as both sides could agree on a new fare, this could be allowed. This is a safeguard to make sure that the driver will not overcharge the passenger by, say, $100 for the same destination. So you can still reach an agreement with the driver. Say instead of going to North Point, I want to go all the way to Quarry Bay. As you explained just now, you can then charge by the meter, right? I just want to make it clear, because if the law is too rigid, then disputes may arise.
即係可以嘅。
I think the Deputy Secretary is saying that you should enter into a new contract. If you want to change your destination, then you can make another agreement, because they want to make sure that the original agreement in writing will be adhered to so as to avoid dispute or overcharging. But anyway, let's see what the administration has to say about this. Well, if I have to talk to the fleet operator again over phone and come up with an agreement first, is that what you're saying? That I have to do that first before I can change the journey? Well, the agreed fare is the fare agreed when you make the booking. If you want to make a change, if you want to have some change to your journey, you can have another agreed fare. As long as it's agreed that from point A to point B, the fare is so and so, then there's no charging, no overcharging is allowed. You mean the parties will have to come up with an agreement? Do you mean the driver as well? Well, the taxi driver is operating a taxi belonging to the fleet. So the advance booking scheme is carried out through a platform. So we're not talking about a general or taxi that you held on the street without using the booking platform. If person A boards a taxi going to North Point, and what if he says, I want to make a change? Please take me to Wong Tai Sin, Kowloon. So is it that the fare will be calculated according to the meter, or another call will have to be made? This is most inconvenient to the passenger. So people may abuse the system, saying that he's going to a destination, and when he boards a taxi, he wants to make a change. Well, I don't think the fare is calculated according to the meter. When you board a taxi with an agreed fare, I think when you make the booking, the fare is agreed and it will be shown as such, saying that from point A to point B, the fare is $200, for example. And if the passenger wants to make a change to the destination, of course, there can be a new agreement. But if you cancel the original journey, then it will not be an arrangement based on advance booking. Why is it not done according to the meter? If he wants to go to Wong Tai Sin instead of North Point, of course, the fare is based on the meter. Well, if the booking is done with advance payment, and if I want to make a change all of a sudden, and if I cannot talk to the driver to agree on this, do I have to do this over using an app? Then perhaps it would be to the passenger's disadvantage, in that the payment will be forfeited. Well, when the booking is made on an agreed journey, there's already a scheduled service and a booked service, and the fare will be done in accordance with the booking. Whether payment is made in advance or not, well, it would depend on the design of individual fleet's app. For example, e-payment will be collected first or after the journey. There's no rigid requirement as to the timing of the payment in the law. And if the passenger wants to change the journey, then it has to be mutually agreed. And if one party doesn't agree to the change, then the journey will be cancelled, the booking will be cancelled. It cannot be forced upon the other party if the passenger suddenly wants to make a change. All right, cross 15. It's a markup copy, page 19. Cap 374D, a new A, 2A. There are 7 divisions, 12A to 12Z. 12A, page 19 of the markup copy. In Part 2A, interpretation of specified provision. 12P, Commissioner may invite application for license by a notice published in the Gazette. Invite application for license to operate a taxi fleet, and he may specify the maximum number of licensees or licenses to be issued. And anyone can submit an application for a license to the Commissioner. The application must be made in the form specified by the Commissioner. Mr. Tony Chair, a question about 12B2. The Commissioner may determine the maximum number of licenses to be issued. I know some flexibility will be exercised, but do you have any specific maximum number in mind at this moment? As previously explained, there can be different combinations. We can have a taxi fleet of urban taxis or NT taxi or a mixture of both. If it's a mixed fleet, or you mean the number of invitations? Well, we're talking about the number of licenses, not the number of vehicles. Well, at the very beginning, we would like to issue 3 or 4 licenses so that the market can adapt. If there is more interest expressed in the market, we'll then issue more invitations for a license. So we can sort of know how many vehicles will be involved. In the first round, we think that there will be 3 or 4 licenses, depending on market response to this arrangement. Let's continue. 12B, 12D, page 20. The Commissioner may grant or refuse an application. In determining the application, the Commissioner may take into account 2A to 2D, such as the demand for services provided by the taxi fleet, the level of services already provided by existing taxi fleets, the standard of service provided by these taxi fleets, etc. The Commissioner will have to give a written notice of his decision to the applicant. If the Commissioner refuses the application, he must give reasons. Ms. Doreen Kwan, I know there's another provision on renewal of the license. Basically, the applicant has no right to an appeal. Is that the case? And why? Why is there no right to appeal? On the question of licenses to be issued, and also the renewal of licenses, well, in subsequent clauses, if it says that if a Commissioner refuses the application, the applicant can we can ask a tribunal to review the decision. So there's a right to appeal. I think 12D and 12E should be read together, and that is the decision on application for license as well as issue of license should be read together. On the question of smart commuting, we need data on smart commuting, since taxi fleets will be using electronic systems to run the activities. So it's important that the commissioner should make the data public for the government and for other parties to carry out studies. So I hope the government can make public the numbers, the data in this regard. All right, please consider this suggestion. Mr. Tony Chair, I want to know more about 12E3, bracket 3, and that is the conditions to be attached. The standard of the services is included here. Do you include safety? For example, whether the taxi drivers in question has committed offenses? Would there be requirements on the compliance by taxi drivers? And also the minimum number of taxis required to be operated in the fleet is also a condition. Do you just provide a figure? Not necessarily all the taxis on the road or ready to provide service. Well, it's 12E, and that is when the commissioner grants an application, he can impose certain conditions on the license. And we will consider, for example, 3H, the drivers of taxis. There will be certain requirements imposed. We were talking about the number of taxis, or the standard of the services and safety performance. But there will be certain requirements in the license. What about D? The minimum number of taxis. Yes, the taxis specify the minimum number will be in operation for the service. The operator will need to submit data and records so that we know the minimum number of taxis to be operated. Would that include inclement weather conditions? They will have to offer a certain number of taxis. Would there be certain requirements? Well, we may not impose conditions regarding operation during inclement weather. That is the minimum number of taxis to be offered. Because during such weather conditions, the paramount consideration is safety. So there will be no mandatory requirement on the minimum number of taxis to be operated. Well, we're talking about the number of taxis operated in the fleet, not necessarily the number of taxis that are in operation at any one given time. I have a question about 12E. F, the replacement of the taxis. A license will not last longer than 5 years. Why do you want to impose a condition on the replacement of those taxis? What do you mean by this condition? If the taxis in the fleet have to be replaced under certain circumstances, we would require that they would replace older taxi with newer taxis instead of the other way around. We want to make sure that the age of the taxi fleet is getting younger, not older. We are talking about 3D. Say I submit an application for 300 taxis in my fleet. That would mean that I can have 300 in my license. Not necessarily the number of taxis on the road. I may not have control over the actual number of taxis that are actually offering services. I think you have already clarified this. I just want to reaffirm this. Well, we're talking about the conditions 12E. Let's proceed to 12F.
就車
12F specifies the fee for a taxi fleet license. The fee is specified in Schedule 1A. 12G, page 22 of the marked up copy. It sets out the validity period of a taxi fleet license, which is no longer than 5 years. A licensee may apply with the commissioner for an extension. The commissioner may grant or refuse the application. In the case of refusal, the notice must include the reasons for the refusal. The license may be extended for not more than 5 years and not more than once. Mr. Chan Siu-hong. During the validity period, if the licensee applies with a fleet size of 350, which meets the requirement and hence secures a license, then the licensee decides to increase the fleet size to 1,000, the license will still be valid. What happens if it's the other way around? If the fleet size is reduced, how should we go through the procedures? When we come to 12J, we will then talk about amendments of a license by the licensee. Now, about the stipulated fleet size 350 to 1,000, if the operator at some point owns 1,250 taxis, we still need to clarify whether the number refers to taxis actually applying the streets or stored in the garage. So is it that the licensee condition will act as the gatekeeping condition, right? Because of the number of taxis, because the number of taxis will be recorded by the Transport Department. Page 23, next. 12H. The Commissioner may exempt a fleet licensee from complying with any provision. The Commissioner may also impose exemption on any condition. It refers to any statute applicable to the fleet taxi licensee. 12I. Amendment of license on Commissioner's own initiative. Under 12I, the Commissioner may, on its own initiative, amend the taxi fleet license. However, if before the end of the consultation period, that is 3 months, the licensee gives written notice to the agreeing to the proposed amendment, then it could come to an end. In any case, the Commissioner's decision should be put down in a written notice, and the written notice should also contain the reason of the decision and the effective date. There should be at least an interval of 21 days before the written notice takes effect, because the licensee may apply for ruling from the tribunal. Mr. Rincon, the fleet taxi licensee will of course be putting in a lot of resources. Here, under 12I, the Commissioner is given a lot of power. That means at any time the Commissioner may, on his own initiative, amend the license. Of course, the licensee may apply for a review, but under what circumstances will the Commissioner invoke this power? What is your thinking behind this? We have considered, for example, changes in the operating environment and circumstances. We need to provide flexibility for the Commissioner to be able to amend the license. For example, we require the fleet size to be between 360 to 1,000 for a mixed fleet, for example. If in the future we find it's appropriate to adjust the size upwards, the commissioner should be able to do so. That's exactly what I'm worried about, Chairman. Well, if I do business, I of course will have my own calculations. Now, under 12I, the commissioner may require the operator to procure 200 more taxis because of the keen demand. But what if I've run out of capital? Of course, I still have the avenue of review at the tribunal. But isn't it risky to put in place 12I so that the commissioner may amend the license anytime? Will there be any incentive for a fleet operator? The Transport Department definitely liaises very closely with the licensee. We've included a consultation process for the proposed amendment of the license. And if this is not agreed, there is an appeal mechanism. I believe that the situation will be handled fairly. Mr. Frankie Yik, I'm concerned about the same provision. It seems that the commissioner is given too much power. According to the administration, the matter can be taken to the transport tribunal, so there is an appeal mechanism. But if I am an investor, I'm worried that any amendment may entail a lot of investment. So how do you respond to this comment that the commissioner is given excessive power? When granting the commissioner the power to amend the license, we must bear in mind that subsection 3 still applies. In relation to 12E3, the commissioner may only amend according to subregulation 3. And there is a consultation process. The commissioner must first consult the licensee. The aggrieved licensee likewise will have the avenue of lodging an appeal with a tribunal. In fact, there are similar provisions for the issuance of say, passenger carriage license. So this is not something new. There are similar arrangements for other types of licenses. Mr. Gary Zhang. Since we're talking about licenses, I want to put forward a point of elucidation. For licensing conditions such as the fleet size, ownership, is it entirely up to the commissioner to decide on these matters? Is there a piece of subsidiary legislation to stipulate these matters? Is it that in the future the licensing conditions will be solely decided by the commissioner and the LegCo will have no role to play in the process? 12E sets out the licensing or the scope of the licensing conditions. Say for the minimum number of taxis in the fleet, at the moment it stands at 1,000, but we have taken views from stakeholders. In light of market changes, they might want to expand the fleet. So we need to give the commissioner flexibility to adjust these parameters in light of market changes. Another point is replacement of the taxis. It is quite possible to go through the LegCo process every time if a taxi is to be replaced. These are operational matters, the nitty-gritty that we have to bear in mind. So when adjustments are to be made in light of market changes, the commissioner will be granted power to amend the licensing conditions. I don't know if my feeling is shared by my fellow members here. For the minimum number of taxis and the ownership of taxis, I don't think this is the minor detail, as you put it. This is something major. It is also the linchpin to whether this bill will be effective. I understand your point about flexibility to make amendments. I just don't understand why, if we adopt negative vetting, no flexibility will be allowed. Yes? As far as the law is concerned, the licensing authority is usually empowered to impose licensing conditions. This is an established mechanism. Say for non-franchise buses and public light buses, their licenses are and the terms are decided by the Commissioner for Transport. The Commissioner imposes conditions in these licenses. This is the established practice. Next, 12J. The licensee may also apply to the Commissioner to amend the license conditions. In respect of 12J, bracket 1A to C, such as the number of taxis in the fleet and the registration mark of any taxi in the fleet. The Commissioner may grant or refuse the application as long as the written notice is issued informing the licensee of the decision and the reasons of the refusal. Page 26, 12K. Unless the Commissioner approves, a fleet licensee must not transfer the taxi fleet license. 12L. If the taxi fleet license is amended, cancelled, suspended, or varied, the licensee must deliver the license to the Commissioner within 72 hours after the amendment, etc. Otherwise, the licensee may be subject to a level 1 fine on conviction. And then after receiving the license, the Commissioner may take the appropriate action, such as withholding or revoking the license. 12M. Mr. Frankie Yik. Chairman, 12L2. I think this is the usual practice. The license should be delivered within 72 hours. I find this problematic. 72 hours means 3 days. It doesn't say working days, however. Well, what happens if we have long weekends, public holidays, inclement weather? We will be breaching the regulation here. So instead of 72 hours, I think it would be more appropriate to put down 3 business days or 3 working days. Because if it remains 72 hours, there will be problems. Please consider the suggestion. Next, Mr. Tony Chair. Chairman, also on 12L, bracket 4, a person, and then so on and so forth. Can you explain what a person means? Any person? That means if the licensee breaches the regulation by not surrendering the license to the Commissioner, he'll be in breach of this regulation. But why in Chinese you've put down the words any person? Well, this is the usual drafting practice. I just find the Chinese rendition problematic. Let's hear from the DOJ. I concur with the DS's answer. Usually for such a provision, we use the same drafting style. If you just look at the sub-regulation 2, we make a reference to fleet licensee. Chairman, but I don't understand. Because you just gave an explanation for a person to mean a licensee. Why not just put down licensee? Next, 12M, duplicate license. If the fleet license is lost, damaged, defaced, or destroyed, the licensee may apply for a duplicate license to be issued. The Commissioner may issue a duplicate which will carry the same effect as the original taxi fleet license. 12N. The Commissioner may issue a taxi or a fleet taxi certificate as set out in Schedule 1A. A fee will be imposed. Page 2812O. Validity period of the fleet taxi certificate. Well, usually it's valid for 12 months, but under the two scenarios, there may be changes. Say if the license is no longer valid, and if the registration mark is no longer specified in the fleet taxi license. 12P, restriction on transfer of a certificate. The certificate must not transfer to another vehicle.
12Q is also about duplicate certificate. If the tax certificate is lost or damaged, then the licensee can apply for a duplicate. Upon payment of a fee, he will get a duplicate certificate, which has the same legal effect. Then 12R, page 29 of the markup copy. According to this provision, the operator of a Tyson Street must maintain proper and efficient tax street services within the license period. The commissioner, in determining whether a fleet licensee is able to do this, he will have regard to certain matters such as the maintains the service in accordance with the specified provisions, the terms and conditions of the taxi fleet license, and the direction given to the licensee by the commissioner. Next, 12S. Commissioner may, after consulting a fleet licensee, give a direction to the licensee in respect of a matter that relates to the general or specific situation of the taxi fleet license, but such a direction may not be inconsistent with any specified provision in the license. The decision decide if the commissioner decides to exercise the power, he must inform the licensee and give the reasons for the decision. 12T, a fleet licensee must not use a vehicle other than those in the license to operate the service. If a person violates this provision, he may be liable to conviction to a fine at level 2 and imprisonment for 6 months. Again, 12T bracket 2 says a person. It means the licensee, right? It's not the owner of the vehicle or the taxi driver. Yes, it means the licensee because the obligation is imposed on the licensee only. 12U, page 31 of the markup copy. 12U, display of fleet license, tax certificate, and free taxi plate. It provides that a fleet taxi must display a taxi certificate in a manner specified by the commissioner by notice published in the Gazette. 12U bracket 2, a fleet taxi plate which is not in accordance with the design or construction or form specified by the commissioner, or the plate is damaged, then no one must allow the taxi to be used for the purpose of the license. And 12U5, a person must not display a fleet taxi certificate unless it's a vehicle in a fleet taxi. An offense committed in this regard is liable to a fine at level 2, $5,000, and 6 months imprisonment. Well, the certificate, what's the form of the certificate? Is that a piled paper? And also, is the certificate in electronic form? Can a photocopy be used? Well, the certificate is similar in size as the normal vehicle license certificate. It was referred to 12U5. A printout version of the certificate will be acceptable. 12V, documents to be sent for prearranged journey. This regulation applies if a free taxi is hired for a prearranged journey. Before the start of the journey, the licensee must send a document to the hirer specifying the fare. There are two situations here. If the taxi is hired on an agreed fare arrangement, then it means the agreed fare. For example, from point A to point B, the fare is such and such, so the document would specify the agreed fare. Secondly, if it's in any other case, it's the agreed booking fee. For example, the fare shown by the meter plus the agreed booking fee. Then the total fare would be specified in the document sent to the hirer. The document would specify the name of the licensee's taxi fleet license number, and the registration mark of the taxi. A violation of this provision may result in a fine at level 2 and 6 months imprisonment. Mr. Chen Xiu-Hong, on the document to be sent for the prearranged journey starts, it can be in an electronic record covering A, B, C under bracket 2. But if we make reference to other countries such as the mainland or Singapore, their electronic platform will not show any record, any document. It will be shown electronically on the app, saying that your booking has been accepted. You require that the information can be printed out as a document. It will be different from the other taxi hailings or vehicle hiring services offered through an app. I think you want to make sure that there's the document in case of a dispute. So otherwise, it can be just some information stored on the mobile phone. Well, it means here is that it can be either in hard copy form or in the form of an electronic record. We want to make this provision flexible so that if someone makes a booking through telephone, or he may not be using a smartphone, that can be a hard copy. Well, if they make a booking through the phone, how can he get a hard copy? So that hard copy will only be available when the taxi arrives. So will the taxi be equipped with a printer so that there can be a printout? It can be very troublesome. Well, if the hirer has no smartphone and he makes a booking through an ordinary phone, then the hard copy will be given by the taxi driver to the hirer. We just require some simple information. For example, the name of the licensee, the licensee's taxi fleet license number, which has already been, or the registration mark of the taxi has already been pre-printed. So the only information lacking is the agreed fare. Mr. Tony Jia, 12U, I'm rather sensitive to the reference to a person. It's unlike the previous situation whereby a person refers to the licensee. 12U4, a person must not drive or use a hire free taxi. It means any person. If anyone drives a free taxi without displaying the certificate, etc., it's an offense. So it's the normal sense of any person. 12W. Commissioner may appoint public officers to conduct inquiry. If there are two conditions arise, the licensee fails to maintain proper and essential fleet services, or if the conditions and specified provisions have not been complied with. 12X. Commissioner may cancel, etc., the license or certificate. If the Commissioner, having considered a report submitted by the public officer and is satisfied that the licensee has not maintained a reasonable level of service, the Commissioner may take action according to 1A to E, including cancelling the taxi fleet license, suspend the license, vary the license, or cancel the free taxi certificate, or suspend the certificate. If the Commissioner decides to exercise any such power, a decision of the statement will be given with reasons, and the Commissioner decision will take effect following the end of the period of 21 days after the notice is given. 12Y is page 36 of the markup copy. Right to appeal for review by Transport Tribunal. A person aggrieved by the decision by the Commissioner may apply to a Transport Tribunal for review. The application must be made within 21 days beginning on the day the written notice is given, and the person must apply and a definite in respect of a specified decision, including the Commissioner's decision to cancel, to suspend the license, etc. Chairman, can you inform us the membership of the composition of the Transport Tribunal, and what's the caseload of the tribunal at present? We'll provide the information after the meeting. I'm quite concerned about the workload and the number of cases that the tribunal can handle. Legal advisor would say something. We wrote to the government to ask questions about 12Y concerning the definition of specified decision. It's in the paper, paragraph 18 of paper 474. The new definition will not include the Commissioner's decisions in new part 2A, such as 12E Cracker 2, the conditions on the taxi fleet license and the decisions, etc. So such decisions will not be subject to review by the Transport Tribunal. We have been given in paragraph 11 to 14 of CB4 756, bracket 001. So I would like to seek members' views on the response provided by the government. All right, let's move on. 12Z. Any fee paid under this part is not refundable. This is just like the passenger service license fee. Now we move on to a number of stopping places, stands and stopping places of fleet taxis. This is we start with page 38. 28 is about cap 374D, regulation 28 and 29. The Commissioner may cause a public light bus stopping place designated, not including the temporary stands specified by the Commissioner of Police. And page 41, a new 30 capital A, The Commissioner may designate an area of road as an area for a fleet taxi to pick up passengers. The Commissioner may have to designate and delineate on the road by means of a marking.
Mr. Frankie Yik, thank you. Chairman, page 4130A, I mentioned before that fleet taxis may include taxis of different models, including the 60-seat taxi, 60-seaters. There is no LPG model available for 6-seaters, and the fuel cost may be very high. For fleet taxis, the designated stopping place may be available at the BCPs and airports. Now, for 38 fleet taxi stopping places, I earlier asked the administration to consider setting a place for them to wait for other passengers, because if a taxi goes to the airport and then leaves without carrying passenger, the fuel cost may be too high. I want to add the following. For the passenger for a pre-arranged journey to board, or for other passengers in another pre-arranged journey to board. Well, because as I explained, for fleet taxis, the taxis may not be LPG taxis. The fuel cost would be very high. If we don't allow flexibility, it will be difficult for the operator. All right, think about it, please. The administration understood. We'll go back and give it a thought. But fleet taxi should focus on prearranged journeys. It's not the same as street hailing taxis. It's not a taxi stand for the fleet taxi to just pick up passengers off the queue. It is not in line with the original intention of having fleet taxis. I'm not saying that we should have a cab rank for the fleet taxis to wait there. I'm just saying that there should be a stopping place, a waiting area, so to speak, for fleet taxis to wait for a passenger who might be arriving late because of a delayed flight. For the stopping places, the fleet taxi will be allowed to stay there and wait for the passenger to come, instead of having a normal taxi stand. A taxi just comes and goes. I just want to put it on record that for a stopping place mentioned here, it should be somewhere that the fleet taxi can stay and wait for the passenger. Mr. Chan Soo-hong, to pick up on Mr. Frankie Yik's point, I think the administration should go back and think about it. Otherwise, the passenger may arrive late, and the fleet taxi may be required to just circle the place because it cannot stop there. Well, they've already explained that the fleet taxi can wait there, but then you need to amend this section, right? That's not the case. They can stop and wait in the stopping place. What happens if traffic police arrives, and if he chases away the fleet taxi? Can I just tell the police that I need to stop and wait for the passenger? Well, in here, it only says picking up passengers but not dropping off. Because if we go to section 28, for public light buses, you can see it's either picking up or setting down passengers. Perhaps you should spell it out for the benefits of taxi drivers here. You should provide picking up as well as setting down passengers. Now, how it is phrased here is a stopping place for fleet taxi. That means the fleet taxi may stop to pick up a passenger who hired a taxi for a prearranged journey. It's not the case of a stop and go. There is no need to spell it out. But why don't we put down picking up or setting down passengers? Because you can provide clearly here that the fleet taxi cannot stop here without any prearranged journey and just wait for a passenger to use their service. You can make it clear that the fleet taxi stopping place is for the taxi to stop and wait for passengers of a prearranged journey. Mr. Frankie Yik, I agree with Mr. Chan. Here, only picking up passengers is provided, but the law enforcement agency in the future may have another interpretation. That means the fleet taxi cannot set down passengers there. They must go elsewhere. Well, I think this refers to a stopping place designated for the fleet taxi to pick up passengers in a prearranged journey. In other scenarios, the fleet taxi operates the same as a general taxi. There is no restriction on where the passenger is to be dropped off. No, but here it says for fleet taxi stopping places, it's only for picking up of passengers. Because if you set down a passenger in the same area, you can be booked by the police. So will they be allowed to set down passengers there? Through this provision, we want to allow fleet taxis to stop and wait for the passenger for a prearranged journey. This is how it is worded. But like the DS explained, unless it's a restricted area, the fleet taxi may drop off passenger at any place. But in the, I think we can just walk the extra mile and provide setting down passengers as well. It is the case for public light buses. I just want to make it clear. Is it your intention to allow taxis to drop off passengers there, like general taxis? Here, you're talking about something new for fleet taxis only, Mr. Frankie Yik. Well, in fact, I received complaints from public light bus drivers. You have public light bus stands in the streets, but even if I park the PLB in the stand, I will get a ticket for it. So why don't you spell it out and provide setting down passengers here as well? We can go back and give it a thought, but the original intention is very clear. Say for general taxis, they can drop off passengers anywhere they like at the permitted areas of the airport and the BCPs. The same goes for fleet taxis. Only that here we specify stopping places, especially for fleet taxis. We have just so much space in Hong Kong. It may not be the most appropriate way to designate a place for all taxis to pick up and set down passengers there. Mr. Dennis Leung. For Section 30A bracket 1, the Commissioner may designate any area or an area of road as an area of fleet taxi stopping places to wait for passengers for a prearranged journey. How large will this area be? Are we talking about the size of a taxi or one that can accommodate 2 or 3 taxis? This is not a proper stand. This is an area off the side of the road. What if it's a busy section of the road? If the taxi waits there for 5 or 10 minutes for a passenger arriving late, will this have an impact on the traffic flow on the road? Traffic is already busy enough in Hong Kong. How does the Commissioner decide where to designate the area of road? Because if the designated area is too far from the destination, we can't meet the goal of point-to-point transport services. It will be inconvenient. Now, usually we talk about the airports and the BCPs where there tend to be more prearranged journeys. The stopping places will be designated there. Depending on the size of the BCPs and depending on whether we can find a suitable area, we'll designate this place as a stopping place. And regard will be given to whether will cause obstruction or hamper traffic flow. Mr. Chan Siu-Hong. 30A, fleet taxi stopping places. What about general taxis? Will they be allowed to drop off passengers or pick up passengers there? No, it's for fleet taxis. If the answer is in the negative, where do we find the relevant penalty? Well, we'll come to that later. Page 42, Clause 20, Regulation 31 will be amended. Under the current regulation, the Commissioner for Police may designate an area of road as a taxi stand, and we are adding this reference to a fleet taxi stopping place. Same here is worded picking up passengers. Would the administration please also consider including setting down passengers? Be it a designated or temporary stopping place. For general taxis, it's called a taxi stand. Now, can a fleet taxi pick up and drop off passengers at a taxi stand? Yes. Because for fleet taxis, they can pick up or drop off passengers at any taxi stand, right? Yes. Clause 21, page 43 of the markup copy. Regulation 32 of 374D will be amended with reference to a fleet taxi stopping place. Clause 22, page 44 and 45 of the marked up copy. Regulation 33 of 374D will be amended. The driver of a fleet taxi may stop at the fleet taxi stopping place to pick up passengers for a prearranged journey. Clause 23, page 46 of the marked up. Well, this is about offering a receipt. Now, on the request of a passenger, the driver should provide a receipt except the following scenarios. That is, hire of the general taxi under Rule 38 or a fleet taxi hired under an agreed fare arrangements. Under such circumstances, the vehicle will be hired for a certain period of time, and there won't be any flag fall of the meter. But as explained just now, an instrument should be issued setting out the relevant fares as agreed. Clause 24, page 47 of the marked up, amending Regulation 38. We will amend the relevant arrangements for hire of a taxi for a period of time. It applies to a general taxi, not a fleet taxi, because in the previous provision, we already went through the relevant requirements for a fleet taxi. Clause 25, that is page 48 of the marked up amending Regulation 39. In relation to insurance and driving license pursuant to the requirement in Regulation 38, 38 now applies only to a general taxi. So accordingly, in Regulation 39, we're adding the description of a general taxi and that it does not apply to a fleet taxi.
We now move on to clause 26, and that is page 49 and 50 of the markup copy. Apart from some textual amendments, we are talking about 45F, a reference to the licensee of a taxi fleet. Upon request by a police officer, the driver will have to provide the driver's license as well as the name of the fleet licensee. I have a question about 45C on page 49. Smoking is hazardous to health. Why don't you just prohibit smoking in or on the vehicle? And why do you allow the taxi driver to smoke in certain circumstances? We want to suppress or reduce the smoking prevalence rate. There's a requirement on providing information, which include address. Is address really necessary? On the question of providing the address, we hope this can align with other requirements concerning public transport. That is, we want to make it consistent. Why is it necessary? Is the information required really necessary? So apart from the name, we need to know how to contact the person. As for smoking, the driver is not allowed to smoke when there is a passenger. We cannot prohibit smoking when the taxi is not offering service. Of course, if there's a passenger, smoking should not be allowed. When we were talking about the legislation on smoking, we know that in a hotel, smoking is prohibited. If the driver has smoked in the taxi, and when a passenger then boards the taxi, there will be secondary smoking hazards. 45D. If a passenger doesn't wear a seatbelt, he will be asked to leave the service and pay according to the meter. Since not all fares are decided by the meter, so we have to make an amendment to take care for the taxi fleet operations. Now we move on to page 52, amendment to Regulation 47. Originally said no registered owner or driver of taxi shall charge for the hiring of a taxi fare exceeding those specified in Schedule 5, but now some journeys are not charged according to the meter. So we would have the new definition of relevant fare, which means in relation to a general taxi, either is in accordance with the meter, or if it is higher on the whole, then it will be calculated in accordance with the scale of fares specified in Schedule 5. If for a free taxi, if it's a prearranged journey, it can be the agreed fare, or it can be calculated with other arrangements as agreed, which is higher for for prearranged journey, but for the whole. Next, page 53, Regulation 49 is the use of taxi meter. As I've mentioned, some journeys may not involve the use of a taxi meter. So we would like to add a new sub-regulation, bracket 4, capital A, which says regulations 234 doesn't apply in certain cases. Now page 454, regulation 49A is about receipt. As I've explained, sometimes a receipt may not be applicable, so we set out the exceptions to the requirement to issue a receipt. And now we move on. Clause 31, page 55 of the markup copy. Sorry, I want to return to page 53. And that is if the hire for a whole, there's no need to use the taxi meter. But is that required to use the taxi meter? Would the flag be lowered? Well, the light would be on if the flag is not lowered. That's the problem. As I've said, yes, for a person on the street trying to hail a taxi, the light is seen to be on. We don't want to cause misunderstanding because the fare is not determined by the meter. But for the hirer trying to hail a taxi, well, they will know that whether the taxi meter is concealed, is hidden. Well, I think you should provide some indication to other people on the street trying to hail the taxi. Page 52, Regulation 47. There's a new definition. 2A, and a taxi or persons in charge of the taxi. Would you have a definition on who is considered a person in charge of the taxi? It's in 2, and then there's a further explanation of 2A. Well, this is a general law drafting style. In the second part, we said the person who is in charge of a taxi must not charge for the hire of the taxi a fare exceeding the relevant fare. And then we further explain who is in charge of the taxi. And then it will provide a direct provision for the reader of this regulation. Because a person in charge of the taxi only appears here, so we just provide the definition or the explanation here. Let's move on. We have a new Schedule 1A, page 55, fees for taxi fleet license and fleet taxi certificate, which is the same as the passenger service license. Page 56, 57, a new Schedule 4A is added. The road marking and traffic sign for fleet taxi stopping place. And now we move on to clause 33, page 58. starting from page 58 of the markup copy, amending Cap 374D, Schedule 5, Romans number 7, and the $5 booking fee is only applicable for general taxi, because if for a free taxi, if it's an agreed journey, there will be no need to charge the additional $5 of booking fee. Page 62 to page 63, amending Schedule 9, information to be contained in the receipt, which add the Roman number 7 with an additional reference to free taxi. If it's a journey hired on a pre-arranged, pre-agreed fare, then the information will be required. And then there is another provision on the issue of a written receipt if the printer is out of order. That's the same requirement as previously. Next, we move on to Clause 35, page 64 of the markup copy, amending Cap 374G for Regulation 45 with a new subparagraph. Except for a prearranged journey, a free taxi must not use the free taxi stopping place. That is in relation to the question on whether a general taxi can use the free taxi stopping place. The answer is no. And then Clause 37. This is related to the amendment to Cap 374G Regulation 45, and we need to amend the fixed penalty ordinance 67, page 67. We'll have a new reference to free taxi stopping place here. Next, we also have a corresponding amendment to Cap 240A, page 80 of the markup copy, page 82. Now we will move on to page 90 of the markup copy. A number of provisions in the Cap 556 Mass Transit Railway Ordinance. At the appropriate places, we would include the reference to the free taxi stopping places so that the MTRC can designate such stopping places for free taxis as appropriate. You can see this on page 93, page 95, and page 96, the relevant amendments. And now it's clauses 44 and clause 41, starting from page 99 of the markup copy. We amend the prescribed road marking definition to add a reference to Schedule 4A in Cap 374D to cover the stopping places, free taxi stopping places and markings. And then clauses 42 to 45, we start from page 105 of the markup copy. It's Cap 556D of the Mass Transit Railway Ordinance, the bylaws, and we add some reference to the free taxi stopping places. And on page 103, we have a new bracket 1, capital A to Regulation 22 in Cap 556D, stipulating that a vehicle must not enter free taxi stopping places unless the vehicle is a free taxi and enter the stopping place to pick up passengers. I want to clarify a point here. A vehicle must not enter a street stopping place. What do we mean by entering such a fleet taxi? What about passing through the area? Well, it's a designated area. It must not enter the area. Just like the bus-only lane, other vehicles shall not enter the lane. Is that the same case? Yes.
佢咧就
Next. Page 104 of the marked up copy amending Regulation 25 of 556D. The fleet taxi may not stop at the fleet taxi stopping place. And then clause 45, page 107 of the marked up copy, the schedule will be amended to add 22 bracket 1 capital A. For other vehicles entering fleet taxi stopping places, the maximum penalty is a fine of $2,000. This is similar to the penalty for similar offenses. Next. Clause 46, page 110 to 111 of the marked up copy, amending Motor Vehicle Idling Fixed Penalty Ordinance Cap 611. Schedule 1 sets out exemptions. We are adding the reference to fleet taxi and fleet taxi stopping place. We will take a 10-minute break now.